at the previous election. End of quote. From the nature of the relief sought in this petition, Relief B appears to be the major relief on which the other 5 reliefs, that is A, C, D, E, and F, are buttressed. The sources of failure of reliefs A, C, D, E, and F depend on the sources of failure of relief B. For purposes of emphasis, we wish to reproduce petitioner's relief B. It reads, a declaration that based on the data contained in the declaration made by Mrs. Jane Adukwe-Mensah, chairperson of First Respondent and the returning officer for the presidential election held on 7 December 2020, no candidate satisfied the requirement of Article 63 Clause 3 of the 1982 Constitution. Task is to know the data the first respondent presented, which the petitioner was referring to. The data will contain inter alia the total number of votes cast at the election, the total number of valid votes cast, the total number of valid votes cast in favor of the second respondent, and the total number of valid votes cast in favor of the petitioner. A percentage of each of the candidates is then calculated against the total valid votes cast. This is the only way to determine whether or not the second respondent obtained more than 50% of the valid votes cast or not, as the petitioner has challenged. In effect, if the petitioner is able to satisfy this court that the data contained in the declaration made by the chairperson of the first respondent did not give the second respondent more than 50% of the total valid votes cast in the presidential elections on 7 December 2020, then all the other reliefs sought under A, C, D, E, and F must be granted as a matter of course, as that would mean Article 63 Clause 3 has been violated, thus rendering the said declaration unconstitutional, null, and void. The petitioner, in advancing reason to support his petition, contended that the first respondent effected corrections to its original data as announced on 9th December 2020. The said corrections were null and void, as they do not reflect on the declaration made on 9th December 2020. Again, the first respondent did not indicate when the said corrections were made, and also did not involve the petitioner and his agents when making the corrections. The petitioner attached to his petition a pen drive of the video clip of the declaration made by the chairperson of the first respondent, a copy of CI 135, a copy of a press release issued by the first respondent on 10 December 2020, announcing the errors in the declaration and the corrections made, and a few other documents like summary and spreadsheets. According to the petitioner, the first respondent was not fair to him when he failed to engage his agents and to involve them in the corrections of the errors before the declaration. The second respondent, the corrections effected by the first respondent in his press release of 10 December 2020 provided a proper reckoning of the percentage of votes obtained by the second respondent using the valid votes cast rather than total votes cast, and showed that the second respondent obtained more than 50% of the valid vote cast as required under Article 63(3) of the Constitution. He averred that petitioners' claim are anchored on an innocuous mistake made by the first respondent in interchanging total votes cast for valid votes cast when announcing the various percentages obtained by each candidate on 9 December 2020. Second respondent contended strongly that when the total valid votes cast are used as the yardstick, he would still be outright winner of the election by more than 50% of the votes. Second respondent denied allegations of violation of Articles 23 and 296 of the Constitution as misconceived. In the alleged vote pattern and the errors referred to by the petitioner, the second respondent, who denied same, contended that granted the allegations were true, they did not have any effect whatsoever on the result of the election. He said